Chapter 7 on Unessential Stipulations 36 and 37 Vict. C. 66. Sect. 25. Subsect. 7. Stipulations in contracts, as to time or otherwise, which would not before the passing of this Act, i.e. its commencement, i.e. 1st of November, 1875, have been deemed to be, or to have become, of the essence of such contracts in a court of equity, shall receive in all courts the same construction and effect as they would have heretofore received in equity. A. Stipulations in contracts as to time. The phrase essence of the contract has been applied judicially to other cases than those of a vendor and purchaser of real estate, including leaseholds, to which, however, it is primarily and ordinarily applicable. Thus it has been applied to penalties of bonds, and the reduction of the rate of mortgage interest on punctual payment. By time, as between vendor and purchaser, is meant the time for completion of the contract, or for taking any of the steps towards completion, i.e. delivery and return of the abstract of title, objections and requisitions of the purchaser, payment of the deposit or purchase money, delivery of possession, months, prima facie, mean lunar ones. Where time has been originally stipulated to be of the essence by the express agreement of the parties. Rule in equity. The modern tendency is to make it essential. No particular words are necessary to make it of the essence. If the intention appear, time declared essential for one particular is presumably not so for another. The party claiming time to be essential must make the point promptly. Exceptions to rule, where it has been waived by 1. The subsequent conduct of the parties, e.g., their going on negotiating for the completion of the contract, and proceeding in the purchase, after the time. 2. The subsequent agreement of the parties. 2. Where the time so fixed is not expressly stipulated to be of the essence. Rule in equity. The court will, although unreasonable delay will of itself conclude either party, relieve against or enforce specific performance, notwithstanding a failure to keep the dates assigned by the contract either for completion, or for any of the steps towards completion. This is all that is meant when it is said, time is not of the essence in equity. Provided 1. The delay has been unavoidable from the state of the title. The vendor may show a good title at or before the decree or investigation in chambers, on within a reasonable time after. 2. The time has been waived, in the opinion of the court, by subsequent agreement of the parties. 2. Subsequent conduct, treating time as immaterial. 1. 9. A. Purchaser receiving the abstract after the time for delivery. B. Purchaser perusing abstract unnecessarily. C. Purchaser retaining the abstract under circumstances which require its immediate rejection. D. Purchaser not asking for the abstract, or not soon enough. E. Vendor receiving purchaser's requisitions, without reserving his right to object, delivered after the time fixed. F. Neither party taking any step to quicken the other till it is impossible to complete by the day fixed. Waiver of matters which must long precede completion, is a waiver of the time to complete in. In all cases where equity holds time unessential, proper compensation will be given for the delay. Interest belongs to the vendor, rents to the purchaser, from the day for completion. Exceptions to rule, raising a necessary implication that time was of the essence. 1. If the nature of the property require the time to be adhered to. For example, if it be a reversion. 2. A life annuity. 3. A public house. 4. Property of an ecclesiastical corporation, where every day is of consequence, as the vendors may die. If the object of the sale require time to be adhered to. E.g., where it is to pay encumbrances, especially if bearing higher interest, out of the purchase money. 3. If the party insisting on its being essential, the other party having been guilty of delay, and the original time having passed, gives the other reasonable notice, or unreasonably short notice acquiesced in, to complete by a given day, such subsequent time then becomes essential, but ceases to be so, if waived by subsequent agreement. 2. Subsequent conduct. All sorts of notice have been held both reasonable and unreasonable. No rule can be laid down. 4. Options to purchase, which are construed strictly. 5. If the contract be inequitable, e.g., if the purchase money be unreasonably great or inadequate. 3. Where no time has been originally fixed by the parties. This, however, is really a stipulation other than as to time. What has been said of time not being essential, when fixed, where the delay is owing to the state of the title, applies here a fortiori, because the court has not the express stipulation of the parties to struggle against, and the same rule applies where the delay is owing to the conduct of the parties. B. Or otherwise. This involves the doctrine of equity as to relief against forfeitures, and penalties, and other cases in which equity will decree compensation for a breach of the stipulation. I. Forfeitures. Forfeiture, as connected with contracts, is the result of a breach of, or non-compliance with, the condition of a possibly hard bargain, whereby the party committing such breach loses all interest in the property respecting which the contract has been broken. Forfeitures, as punishments annexed by law, and therefore not determined hardly, without contract, to some illegal act or neglect, are not within this subsection, nor within sect. 11. Because equity will not relieve against them, and there is no conflict. 2. Penalties. A penalty, alias the penal part of a contract, alias a nomi in pen, is an engagement to pay a sum greater than that which is actually due, and than the parties intended should be recoverable, and is a punishment or infliction for not doing something, and therefore money due on contract cannot be converted into a penalty. The question is one of intention, to be gathered from a construction of the whole instrument. The test, in deciding penalty or no penalty, is whether the penalty is part of the contract, or is only to secure performance of the contract, whether the parties mean that one party shall have the right to do the act to which the penalty is attached, paying what is agreed on as an equivalent, or whether he is restricted by the contract from doing that particular act at all. If one covenant not to do an act, and a penalty is attached to the doing of it, the penalty does not authorize the doing of the act, and the court will before the act is done enjoin, if it has been done, the penalty must be paid. Liquidated damages, on the contrary, alias stipulated damages, alias a sum in solido, though larger in amount than the sum actually due, or originally contracted to be paid, are damages fixed on by the parties as the measure of loss to be sustained by the injured party by breach of a contract, and are not in the nature of a penalty, and will therefore be held essential in equity, and not relieved from. But neither the words penalty, nor penal sum, nor liquidated damages, are conclusive of the character of the instrument. 1. Breaches of, or non-compliance with, the penal part of a contract, which are not of the essence of the contract in equity. I. Non-payment of mortgage principal and interest at the day named. This, however, is really a stipulation as to time. 2. Breach of covenant to insure against fire. 3. Penalty on a common money bond. 4. Penalty to secure the enjoyment of a collateral object. V. Non-payment, even by copyholders, of rent, or fines. Equity relieving, as well where there is a proviso for cessor, and where therefore it might be argued there is no longer anything for the court to act on, as where the proviso is for re-entry. In the case cited, however, the court laid down no general proposition, provided, in the case of rent, a lessee pay rent and costs and proceed for relief in equity or at law, as directed by the Common Law Procedure Acts. A new lease is in such a case not necessary. B. Lessor has a right by law to re-enter, whether he actually enter or no. A lessor has no such right unless he expressly reserve it. C. Lessee has not committed other breaches of contract for which he might be ejected at law. 2. Breaches which equity deems essential, and will not relieve against. I. Covenant to repair generally or specifically. This last is, however, really a stipulation as to time. 2. Covenant to build within a given time. This is, however, really a stipulation as to time. 3. Covenant to cultivate land in a husband-like way. 4. Covenant not to carry on trade in a house. V. Covenant not to assign or let without leave. Vi. Breaches by shareholders of the company's bylaws. 7. Breaches of provisions in a statute. 3. Compensation for breach of stipulation by misdescription of the quantity or quality of the estate purchased, or of vendor's interest. Rule in equity. Where a misdescription is small, equity will, nevertheless, decree specific performance. the purchaser giving or receiving compensation. But where it is substantial, e.g., the nature of the tenure, as copyhold for freehold, or in quantity, as an underlease for a lease, it is of the essence, unless waived. Equity will more readily consider the stipulation unessential at the instance of a purchaser, than of a vendor, since the latter is author of the error. Exceptions to rule: if the purchaser knew the vendor had less than he stipulated for, in which case, if the knowledge be express, his action will be dismissed. He will not be entitled to take it with compensation. Constructive knowledge will not disentitle him to specific performance without compensation. If he suppress wrongful acts done by himself, the knowledge of which would have given vendor a claim against him,